Donald Trump's defense issues the final reply in the battle over presidential immunity. Trump's team submitted this some time ago, and they told Judge Chutkan, as the president, it comes with certain privileges and immunities, which means that Trump cannot be prosecuted for doing things that were in the confines of his job as the executive of the country. And so he submitted the motion, and it was a nice one, a big one. We covered it here. Certainly encourage you to start there if you want to watch the background on this. But then, as we know, in Trump's motion to dismiss, it's not the final word the first time. Jack Smith gets the opportunity to respond, and then Trump gets the final say. It's kind of like a sandwich. Trump goes first, Jack Smith goes second, Trump gets the final word. And so we're going to take a look at Trump's final word, which is called the reply, on this immunity issue, because Trump says it's such a big issue, the entire case should be dismissed because of Trump's status as the president. And so we'll go into that. Now, I want to share with you that the Jack Smith motion is available on the mind map. You can sign up for the mind map at robertgovea.com if you want to read the full thing and access it on our website at robertgovea.com when it is published. But I want to just show you and hit the highlights of it, and we'll fast forward to Trump's reply, which will incorporate a lot of this because he's responding to it. So here you can see it was a big one. 54 pages. This is from Jack Smith, the so-called special counsel. He is special. Here, the government's response in opposition to Trump's motion to dismiss the whole case on presidential immunity grounds. Now you can see it says a former president has no immunity from federal criminal prosecution. No constitutional provision or historical practice supports this, saying that the other civil liability that we saw in another companion case doesn't apply. Here, we would be creating novel immunity, and that even if Trump were entitled to immunity, it would not be warranting a dismissal in this case, right? And so it's a big, long filing. You can see all the cases, and it's all here. And because the Trump reply will incorporate a lot of it, this is what Trump says. This is the final word before it lands on Judge Chutkan's desk. Trump's defense says, Your Honor, this is Trump's reply in support of his motion to dismiss based on presidential immunity, saying the following. Your Honor, Judge Chutkan, the question of presidential immunity is a weighty one, intertwined with fundamental issues regarding our Constitution's structure, our history and traditions, and the president's unique role as the leader of our country. Although not yet resolved by the Supreme Court or any court, because all prosecutors until now have respected presidential immunity. That's why we haven't had to deal with this before. The legal underpinnings and the need for such protections are manifest. They're evident, self-evident. As the Supreme Court held in Nixon versus Fitzgerald, the civil liability case, the president must have the ability to make decisive and often unpopular decisions regarding matters of public concern. Just as he cannot be constrained by fear of civil lawsuits, like we saw in the prior case, so too should the president be protected from the much more potent specter of criminal prosecution by people like Big Fanny and Tish. To hold otherwise would require the president to hesitate at every turn, conscious of the very real threat that one of many hundreds of prosecutors around the country may one day question and file charges and seek to imprison him for his actions as president. Nor would recognizing criminal immunity actually place the president above the law, as the prosecution claims. Rather, it would return us to the sensible process envisioned by the founders, where the people's representatives in Congress, not an unelected prosecutor, first decide whether a president's official actions are worthy of sanctions and potential criminal liability. That has not occurred, and in fact, the Senate acquitted President Trump of charges formed from the same basis as this indictment. And so accordingly, Your Honor, the court should hold that President Trump is immune from criminal prosecution for the act described in the indictment and dismiss this case with prejudice, meaning it is not coming back. Don't even try it. And what they're talking about is the political process for trying a president accused of wrongdoing, right? High crimes, treason, high crimes and misdemeanors. So you go through the process, and the people in the Senate, the elected senators, they kind of get to act as America's jury, right? Evidence is presented and they get to vote because we have a concern that maybe it's criminal, but maybe it's political, and we don't want political prosecutions, what could be a political prosecution, to a political body. If they say, yep, it was criminal, it'll be overwhelming. They'll convict him, put him out of the political process, back into the civilian process, and prosecute accordingly. But that's not what's happened here. They have actually acquitted Trump, and they've prosecuted him anyways 4 times. They say, Chutkan, the prosecution here, Jack Smith, the range thugs over there, says that they argue that presidential immunity does not extend to criminal prosecution of a president for his official acts. But the prosecution is wrong. First, the prosecution argues that recognizing immunity from criminal prosecution would place the president, quote, above the law. But they say, no, that's not true. As the prosecution recognizes, the president is subject to criminal prosecution for one 1, unofficial conduct or purely private acts. If he did something like went out on Fifth Street and blasted somebody, that's not in the confines of presidential duties. Or 2, conduct within the scope of his official responsibilities, provided that he's first impeached by the House and convicted by the Senate. So he's not, in fact, above the law at all. The impeachment judgment clause in the Constitution states that after a trial in the Senate, quote, the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. It's in the Constitution. The clause authorizes the prosecution of a president for conduct that was committed while in office if he is first, quote, convicted in the Senate. You go through the political protection process first, then you can go into the actual indictment in the civilian, regular criminal justice system. They give us some historical examples, telling us about Alexander Hamilton. They say, Your Honor, Chutkan, the historical authorities that were cited by the prosecution, they actually contemplate this same sequence, right? In other words, they've told you what I just told you in their own filings. For example, they quote Hamilton in Federalist number 65. He said when he wrote back then, quote, after having been sentenced to a perpetual ostracism from the esteem and confidence and honors and emoluments of this country through impeachment and conviction by the Senate, okay, impeachment and conviction, after he will still be liable to prosecution and punishment in the ordinary course of the law. And the Federalist Papers and the Anti-Federalist Papers were documents that our founders were sending and publishing to debate the creation of the Constitution and the founding of the country. So they looked to them to say, well, when they were writing the Constitution, what did they mean? Alexander Hamilton said that after you can then prosecute. So recognizing even then that presidential immunity from criminal prosecution, therefore, does not in fact place a president, quote, above the law because he can still be prosecuted. There are still modalities to get to him or her, that he may never be prosecuted for official acts. It's not true. There's 2 mechanisms by which it can happen. Instead, it affirms that the careful safeguards the framers erected around the presidency were done for the public good. And it ensures that only Congress, only the people's representatives, may decide when and whether the president shall be liable to indictment, trial, judgment, and punishment according to the law. He was not convicted in the Senate, therefore he is immune from other prosecutions for that conduct. Now they say the text of the Constitution requires presidential immunity. Just read it. The prosecution next says, Jack Smith, that immunity cannot lie because no provision of the Constitution explicitly grants it, saying it's not written in there though. This again is incorrect. As an initial matter, even absent specific textual support, Supreme Court has recognized repeatedly broad immunity doctrines, including judicial immunity and the president's absolute civil immunity before. They found that the civil immunity exists and there's no specific textual basis in there for that one. Thus, the absence of a specific, quote, presidential immunity clause is not determinative, okay? Supreme Court already got around that one. Nice try. Rather, the court must look to the text of the Constitution in conjunction with the policies and the principles that are implicit in the office and then make a decision on the basis of that. Regardless, the text of the Constitution, namely the impeachment judgment clause, straightforwardly supports presidential immunity absent conviction in the Senate. The clause provides that the party convicted, with an ED at the end, shall nevertheless then be liable. So the most natural interpretation of that is what it says, that a convicted party is then liable to criminal prosecution. Thus, a president who is not convicted is not liable. Oh my gosh, hopefully they're following this over there at the DOJ. I'm not sure. Maybe the highlighter girl should get out her highlighters and diagram this out on a whiteboard. The prosecution attempts to evade this clear language by arguing that that clause in referencing criminal prosecution after conviction of the Senate somehow strips the president of criminal immunity, regardless of the Senate's decision. They say, but this argument flips the plain text of the Constitution on its head. Indeed, if the prosecution were correct, the phrase party convicted would be rendered a nullity. The president would be charged under any circumstance. That's clearly incorrect. You can see Marbury versus Madison about that. Historical authorities, including those cited by the prosecution, support the interpretation that a Senate conviction is a prerequisite for criminal prosecution. Alexander Hamilton said the same thing. The President of the United States would be liable to be impeached, tried, and upon conviction, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of the law. So he said it again in 69, Federalist 69. Now the word afterwards, the prosecution leaves out of its brief. Oh, they don't want to talk about that. They then instead, no, it would be incongruous and strained to have presidential immunity. But they say no. The Constitution is designed for this. The requirement of impeachment and conviction by the Senate assures that a president can be held held criminally responsible for actions in his office, but only if there is broad political consensus to do so. That's why 2 houses of Congress, including a supermajority of the senators, are required. But once the charges of the president have been tested through this, and if they have been found to have been meritorious, then you can treat the former president on the same footing as the other citizens, because it has been proven that it is not political. It's not political because we know that the president's own party, the president's own people, found through a supermajority that he was guilty of the thing. Then you can kick him out. Okay, it's not politics. Everybody agrees. Now go convict him. But consistent with this, the Supreme Court has repeatedly emphasized that the primary check on a president's wrongdoing is impeachment. Fitzgerald, the other case, said that itself. Therefore, the fact that some presidents remain immune from prosecution because they were never impeached is not a yawning impunity gap. And they continue. They say the prosecution finally speculates. They give us some historical precedent. They say a lot of other history supports this, okay? It's not only Alexander Hamilton, a lot of other people. He used the word subsequent, a subsequent prosecution in Federalist number 77. The prosecution also relies on an Aaron Burr statement, and the government is also citing some other cases. But here, prosecuting President Trump breaches centuries of unbroken tradition, because they are breaking glass in case of emergency. Here, the government argues that the fact that no former president has been criminally prosecuted reflects not a history and tradition implying the existence of criminal immunity, but the fact that other presidents just haven't been bad as Trump. On the contrary, American history teems with situations where the opposing party vigorously contended that a sitting president acted criminally in their official duties. But it only took until 2023 until the Democrats did this. Okay, they all did it. We've never had a president before that the other side says broke the law ever until Trump showed up. Are you serious? Deluded psychos. So for example, in the 1824 election, Andrew Jackson supporters accused John Quincy Adams of effecting a corrupt bargain with Henry Clay when they appointed him Secretary of State in exchange of using his influence to deliver the election to Adams. So in other words, John Quincy Adams brought somebody in, appointed them after they delivered the votes in the House because it was contested. So in the 1876 election, President Grant dispatched federal troops to disputed states to ensure that Republican-controlled canvassing committees could organize just enough pro-Republican slates of electors to elect Rutherford B. Hayes, after Hayes lost the popular vote. Nixon was widely accused of criminal obstruction of justice for Saturday Night Massacres and the Watergate special prosecutor firing. Bush, his critics widely accused him of lying to Congress to induce the Iraq War, getting us into Saddam Hussein. Obama was criticized for personally authorizing the extrajudicial killing of a United States citizen through a CIA kill list and a drone strike that killed the citizen and his 16-year-old son, another U.S. citizen. American history provides further examples of this. A lot of criminal conduct. Can you charge Obama with murder? Though many at the time believed these official actions were criminal and their political opponents eventually took power in every case, none of these presidents were ever charged with a crime for their official acts. Our history reflects a strong tradition against prosecuting presidents for their official acts until Trump. But they say that Trump is just the worst. A lot of other people have been prosecuted, but the presidency's absence for the list, mayors, sheriffs, governors, VPs, cabinets, they've all been prosecuted, but not presidents. Why? Immunity. They say that Fitzgerald actually supports their claim, and this is the civil case. They say the reasoning of Fitzgerald is very similar here, and it also supports finding criminal immunity in this case. So it applied civilly when Nixon was being sued. It's why it should apply here. A president must be able to pursue his duties, and they are sensitive and far-reaching. So if we allow the president to be prosecuted for everything, he won't be able to do his job. Very other similar immunity doctrines are also similar, like a judge cannot be criminally liable in certain contexts. We have other types of immunity, like qualified immunity and so on. There are already adequate safeguards here. The president can be prosecuted in other contexts. And here, all the things that Trump did are immune. So we've been talking about this outer perimeter test, right? There's some conduct that Trump is involved in that is clearly within the presidency's duties. There's some conduct that is clearly outside of the president's duties. And then there's probably some stuff that's kind of right there in the middle, borderline. So they say, Your Honor, unable to deny that the vast majority of Trump's alleged conducts, which was within the outer perimeter of his duties, the prosecution does not even try. Instead, it devotes the bulk of its brief to arguing that Trump's criminal immunity does not exist, or it should apply with less force than the other case. The prosecution, though, presents no argument at all about most of their allegations, apparently conceding that they would meet the Fitzgerald test, consistent with the appropriately broad duties of the president. presidency. So the few remaining arguments are meritless. And so these allegations have all been characterized properly, and organizing alternative slates of electors is immune. Some of Trump's conduct, they say, was purely private, but they say no. Here, organizing alternative slates of electors is immune, and it's presidential conduct in itself, and preparatory to the immune presidential conduct of communicating with Congress about the certification proceedings. They say the president, first, organizing slates of electors is within the rights and duties. It comes literally out of the Constitution, and that's what the president enforces. History confirms that the organizing alternate slates of electors are within the presidential duties because President Grant himself was directly involved in and supported the slates of Republican electors back in 1867. In that election, both sides declared fraud. President Grant directly supported Republican efforts to organize alternate slates of electors, and nobody prosecuted him for it. These were presidential acts, and they reflected Grant's direct involvement in the organizing slates of electors that he viewed as fraud. They say, accordingly, based on all of this, Your Honor, presidential immunity applies, and this case should be dismissed with prejudice. Signed by your friends John Lauro and Todd Blanche over from the Trump defense team. And man, they have just so many different motions to dismiss filed right now. Judge Chutkan and Jack Smith, they're getting all these new filings every day. Motions to dismiss for constitutional violations, for statutory violations, vindictive and selective prosecution, and of course, presidential immunity as well. And my thought is on all of these that they're all going to be denied. All right. It's Judge Chutkan we're talking about. We're talking about the District of Columbia. But when Trump loses these, we're going to have an issue of collateral consequences, right? External consequences. Trump may be filing interlocutory appeals saying, Your Honor, I cannot wait to appeal this until the conclusion of my criminal case here. Why? Because I will lose my election time. I will lose all of this time, and it will impact my political rights, my First Amendment rights, and all of these other rights. And so we're going to see that these motions to dismiss are coming in as anchors just to etch in stone and to make the record clear that Trump is a victim of all sorts of egregious violations, and then Trump and his team will respond in time. Now, what's interesting about this is all of these motions to dismiss are all showing all of the various violations that we're sitting here witnessing are coming from Trump's political opponents. Okay, in other words, Trump is the victim of a political onslaught. 4 different criminal charges, all filed right in the same year so that they all climax right in the middle of an election season, orchestrated in various states, civil lawsuits brought by Bergdorf's and by Tisch and others, right? It is an orchestrated attack on the guy. But what's funny is they're all freaked out that if Trump wins and he continues to go up in the polls, every time they indict him, every time there's a new problem, he does better. But they're saying Trump, when he gets in office, he's going to all be about retribution.
What do you think Trump would be like as president if he wins in 24?
Well, he's already saying it's going to be about retribution, and he's a very petty man, and it's all about him. And he's a very fragile ego, and something happened to him as a kid, and I'm not going to spend time psychoanalyzing it. But every encounter he has to come out showing the other guy that he's better. It's all about the assertion of his ego, and I think he will be self-indulgent in a new administration, and won't be as effective as he could otherwise be, and probably things would start moving toward chaos.
Oh yeah, chaos for what? The DOJ? Chaos for what? The FBI? Or your cronies who all have been prosecuting Trump and orchestrating this attack? Well, that's what we're kind of looking for. We're looking for some retribution because what is being done to him is not appropriate. And if they're going to break glass in case of emergency and start prosecuting their political enemies, Trump has every right to hop in office and do the same thing. And so, of course, we'll be here continuing to cover, my friends. I hope you join us. Thank you for subscribing to our channel. Thank you for checking out robertgovea.com. We've got a daily newsletter there that goes out where all of these videos are summarized. So in case you missed the show, in case you missed a full segment, you get them delivered to your inbox. We'd love it if you forwarded it to somebody, but if not, just delete it. No problem at all. And we'll look forward to seeing you on the next one.